Lord, I wish to say that this is a case which goes to the very root of our democracy.
Yes.
And I am glad, my lord, that the court has finally fixed it for hearing and constituted a constitutional bench, given the importance of the case. Lord, I have been in the PIL space for many years, but I have never seen this kind of public interest involved in any PIL that I have ever done. I mean, the amount of interest that this has aroused is absolutely astounding. Lord, there are, I'll just show your lordship what the electoral bond scheme is. By this petition, my lord, we have this, I am appearing for ADR, and we have filed written submissions which are in volume 1 and start at page 1. We have, in our written submissions, my lord, mentioned that we are challenging in our petition also, we are challenging the amendments brought in FCRA by the Finance Act of 2016. So first, my lord, in 2016, and the issue about whether they could have been brought through the Finance Act or not, I am not pressing right now, though we have taken that issue in our petition. But I am not pressing it for the reason that I want this case to be decided before the elections. I don't want, because I know that your lordship has issued the finance bill issue to a 7-judge bench, and I don't want this to await that. So I'm restricting myself to the other grounds of challenge. So first, my lord, we have challenged the amendments brought to the Foreign Contribution Regulation Act of 26 by the Finance Act of 2016. And in essence, my lord, those amendments were that prior to that amendment, we have actually in our written submissions, my lord, we have given a chart of the amendments. And the amendment regarding the FCRA is at page 10.
I'm sorry, generally, my lord, we don't interrupt. But by a judicial order, my lords have been pleased to separate and detag the issue regarding FCRA. There is a judicial order passed by your lordships.
No, my lord,
Lord, he has started with that, my lord. Therefore, it's
I'm
seems
just
he has
pointing
missed
out
that
what
order.
we have challenged in this petition. If your lordship just sees, in this petition, which is before your lordship today, we have challenged the amendments made to the FCRA also by way of the Finance Bill of 2016. And the amendment was that prior to that, the foreign contributions were prohibited to political parties and candidates and public servants. By this amendment, they have effectively permitted foreign contributions by saying that any contribution made by way of donation through a subsidiary of a foreign company which is registered in India will not be treated as a foreign source. So by this amendment, effectively, you have allowed, so for example, my lord, suppose, I'm just giving an example, a foreign company wanted to donate money to a political party. It was earlier totally prohibited from doing so, and in fact, one of these cases went to in fact, this amendment was in a way brought in order to overcome a judgment of the Delhi High Court, by which the Delhi High Court held that both the BJP and the Congress party had received foreign contributions through a subsidiary of a foreign company. At that time, it was Sterlite, which was a subsidiary of Vedant Resources, which was a UK-based company. And they said that therefore appropriate action should be taken against these political parties. To overcome that, my lord, a retrospective amendment was brought through the Finance Act into FCRA by saying that if the donation is made by a subsidiary of a foreign company, in that case also that was a subsidiary, Sterlite was a subsidiary of Vedant Resources UK, then that will not be treated to be a foreign source. So this is the amendment which has been brought, and we have mentioned this, my lord, at page 10 of our written
That
submission.
has strictly speaking no relevance to the challenge on the electoral bond scheme.
True. But I am only saying that.
Which is perhaps why the solicitor mentioned that.
Yes, but
that has been
my lord,
detagged.
that
That issue was
electoral bond
detagged.
scheme,
Segregation of 3 cases. 31st of January 23 order. Your lordships, my lord, were pleased to segregate.
in this, my lord, the original amendment of brought in by the Finance Bill of 2016 to the FCRA has been
All
challenged.
right. What is the next challenge in your petition? We'll just at least have a broad
Yes.
purview and then we can go on to
Yes.
the.
So the challenges are all in this chart, if your lordship just sees.
Page 10.
Page 7, volume 1, page 7, in our written submissions. Yes. So first is the amendment made to the Representation of People Act. Earlier, my lord, the Act said 29C. On the left side is the original and the right side is the amendment. Amended. Earlier, my lord, the Act said, RP Act said, the treasurer of a political party or any other person authorized by the political party in this behalf shall in each financial year prepare a report in respect of the following, namely, A, the contributions in excess of 20,000 rupees received by such political party from any person in that financial year. B, the contribution in excess of 20,000 rupees received by such political party from companies other than government companies in that
you are at page 10.
Pardon, Lord?
You are at page 10.
Page 10. At the bottom, 7, sorry.
Seven.
I'm sorry, page 7. Page 10 was that FCRA I had taken the one. Page 7.
Yes.
So, left side is the original provision. And then, my lord, 4 said, where the treasurer on the left side, original, where the treasurer of any political party or any other person authorized by the political party in this behalf fails to submit a report under subsection 3, then notwithstanding anything contained in the Income Tax Act, such political party shall not be entitled to any tax relief under that act, because contributions to political parties are exempted at both ends. That is, it's exempted at the end of the party which receives the donations from tax, and it is also exempted at the end of the donor. That is, the donor can claim an exemption by way of the donations that they have given to a political party. Now, your lordship will see the amendment. I have highlighted the relevant part. Provided on the right side, provided that nothing in this subsection shall apply to contributions received by way of electoral bonds. So therefore, the reporting requirement as to who has donated to you in excess of 20,000, which was earlier there, has been removed for donations received through electoral bonds. This is the first amendment to the Representation of People Act. Then they amended simultaneously the Companies Act. All these amendments were brought in through the Finance Bill of 2017. Finance Act of 2017. Now the Companies Act 182 originally prescribed, notwithstanding anything contained in any other provision, a company other than a government company and a company which has been in existence for less than 3 financial years may contribute any amount directly or indirectly to any political party, provided that the amount referred to in subsection 1, as the case may be, the aggregate of the amounts that may be so contributed by the company in any financial year shall not exceed, this is important, shall not exceed 7.5% of its average net profits during 3 immediately preceding financial years. So there was a limit, there was a cap of 7.5% of last 3 years average profits on the amount of corporate donations that any company could give to a political party. That proviso has been omitted by this amendment. So this is another thing other than electoral bond. Simultaneously, my lord, a slew of changes were made. One was, and all these have been challenged in our petition. Then, my lord, 182.3. Every company shall disclose in its annual profit and loss account any amount or amounts contributed by it to any political party during the financial year to which the account relates, giving particulars of the total amount contributed and the name of the party which has to which such amount has been contributed. So earlier the requirement was